afternoon, everyone. Thank you for attending our second webinar of a three-part complimentary webinar series discussing California's new affordable housing laws. What are the legal and business implications? We hope you enjoyed today's presentation and mark your calendars to attend the final webinar on February 8th. A few things to get us started for today's webinar. All of your telephone lines are muted. On the top of your screen, there's a Q&A button. During the webinar, if you would like to ask the presenters a question, please submit your questions using the Q&A button. John Bacher and John Getz will do their best to answer all questions during or at the conclusion of the webinar. We have quite a few attendees registered today, so if your question isn't answered, we will follow up with you after the webinar via email. We are offering CLE credit for this webinar. CLE certificates and a copy of the PowerPoint will be emailed to all attendees next week. And now for our webinar. Governor Brown signed 15 bills into law on September 29, 2017 that are designed to help address California's affordable housing crisis. The approved bills take different approaches to the housing shortage in California, including providing more funding for affordable housing development, streamlining local government approval of housing projects, restoring local government's authority to impose inclusionary housing requirements on private housing developers, and strengthening the state's anti-NIMBY laws. The new laws have broad implications and obligations for local municipalities, housing-related public agencies, and the private developer community. To help explain the new affordable housing regulatory landscape, on January 11th, we discussed SB2, SB3, AB 1505, AB 1598, and approaches being taken by local governments, including bond measures in Bay Area counties and a linkage fee in the city of Los Angeles. Today, John Bacher and John Getz will discuss new methods for streamlining housing approvals, including Senate Bill 35, Streamlined Approval Process for Housing Projects, Senate Bill 540, Workforce Housing Opportunity Zones, Assembly Bill 73, Housing Sustainability Districts, and using existing planning and Sequa tools to streamline approval process for housing projects. John Bacher chairs the firm's Municipal and Special District Law Practice Group. He currently serves as City Attorney for the City of Dublin and General Counsel for the Bayshore Sanitary District, Kensington Fire Protection District, Napa Sanitation District, and Tamaulipas Community Services District. John's public law expertise focuses on land use, housing, economic development, finance, elections, governance, Political Reform Act compliance, and energy and public utilities. John has specialty expertise in funding issues related to public infrastructure projects, which includes advising clients on compliance with Proposition 13, Proposition 218, and the Mitigation Fee Act. He also is recognized as an expert in all aspects of local agency formation commission proceedings. John Getz is a principal at Meyers Nave. He has 30 years of experience in real estate, land use, environmental, redevelopment, affordable housing, and municipal law. John represents a broad spectrum of cities, housing authorities, universities, private sector landowners, and real estate developers. He advises on real estate transactions, land use planning, public-private development, infrastructure financing, and affordable housing transactions. He also has advised on more than 150 housing developments and programs involving thousands of affordable and market-rate housing units. His housing projects include a variety of housing types, including affordable rental developments, mixed income for sale housing communities, master plan communities, and mixed-use and transit-oriented developments. John and John, thank you for being here with us today.
Thank you, Stephanie. So I'm John Bacher. I'm going to go ahead and get started and talk about SB35. So first of all, let's look at this from a housing developer's perspective in regards to the benefits of SB35, which is, if you just look at it generally, is a piece of legislation designed to streamline the approval process for certain types of residential projects. We're going to get into details about what those projects are, what types of projects are streamlinable under SB35. But just to look at this from a housing developer perspective in terms of the benefits and the drawbacks. First of all, there's no design in terms of the benefits. There's no subjective design requirements. So unlike many projects, there's no subjectivity. The local agency can only apply objective requirements. Projects are deemed to be ministerial if they meet the requirements of SB35, so there's no Sequa. The determinations have to be made very quickly, as we'll get into. You're exempt from growth control measures, and in many cases there are very favorable parking standards, and in some cases no parking standards. But there are also some big drawbacks that come with SB35 compliance that apply to at least some projects. There are prevailing wage requirements, and there are also substantial requirements in terms of your workforce. And basically, those can be very costly for developers. In most cases, there are affordable housing requirements that come with a SB35 project. In some cases, they're very substantial. SB35 projects also may not involve projects that require a subdivision. So if you're trying to do a condominium project at the same time that you're having the project itself approved, you're not going to be eligible for SB35. They're also not available in sensitive locations, and we'll get into that in a little bit more detail later. And finally, there's a high litigation probability if you attempt to use SB35. At least there's some uncertainty about whether you'll be able to rely upon it. Now, in terms of, from the city and county perspective, the benefits and drawbacks, it reduces the influence of NIMBYs. That can be perceived as a benefit for some staffs and even some city councils and county boards of supervisors. It also reduces the barriers to meeting RENA goals. Of course, the biggest drawback is the loss of local control and preemption over density and also aesthetics. There may be some difficulty mitigating environmental impacts. Projects may end up being underparked. And there's also the fact that the way the bill operates, you're being held to RENA numbers that is not really within the agency's ability to control entirely, because all you're obligated to do under RENA is plan for development, not actually produce it. That's up to the private sector. Okay, so let's get into the details about what projects are eligible for SB35. Well, first of all, this is how SB35 works. A project that meets SB35 qualifications are entitled to ministerial streamlined processing. So the agency has 60 days and 90 days if it's a project larger than 150 units to determine whether or not a project is eligible for treatment under SB35. And then there's another 30 days after that for the agency to complete design review and or public oversight of the project, if that's desired. So there's the ability to have some form of public oversight in that 30-day period after the initial determination. Now, it's ministerial, so that means there's no Sequa, as I already discussed. So, eligibility. Only projects that HCD has determined or only jurisdictions that HCD has determined are subject to SB35 are going to be eligible, or the projects within that jurisdiction are going to be eligible only if HCD has determined that the agency is subject to SB35. So how is HCD going to make that determination? They're supposed to determine whether the number of units that have been issued permits is less than the locality's share of regional housing needs by income category for that reporting period. So HCD is going to look at your housing elements and determine whether or not the building permits you've issued during that time frame are meeting regional housing needs by income category. I think there are very few jurisdictions in the state that are actually meeting in terms of issued building permits the regional housing needs by income category for a particular reporting period. You might be meeting them in one or two income categories, but it's very rare that there's a jurisdiction that has represented in all income categories. Now, the way this reporting period business works is there are two reporting periods during the 10-year RENA period. There's the first half and the second half of the assessment period. And then the determination remains in effect until HCD makes a determination for the next reporting period. I'm not certain whether HCD could decide that it made a mistake on a previous determination and reissue a determination. Perhaps it can. We'll have to see how they decide to implement these determinations. In terms of eligibility, I mean, one of the obvious requirements is the project has to be multifamily housing development. That simply means, under the statute, 2 or more units. This is the project affordability requirements are one of the most counterintuitive aspects of the bill. If the way this works is that if an agency is meeting the demand, its RENA demand for above moderate, in the above moderate income category, then a developer has to devote at least 50% of the units as affordable units. Whereas if the project is, or the jurisdiction is not meeting its above moderate income requirement, then the affordability standard is only 10%. That's a little bit counterintuitive, but if you think about it in the sense that the bill is trying to make it easier to build housing in those communities that aren't meeting their sort of market rate obligation to build housing. That's why the standard is higher for affordability in the moderate income than it is in those jurisdictions that are not meeting their above moderate income standard. Okay. So the site actually has to be in an urban location, and the reference here is to various census designations of urbanized area, urban cluster. I've looked at some of these designations, and it appears that most communities that are developed in any kind of way are going to be designated urbanized areas or urban clusters. You ultimately just have to look this up and see if a particular community is within an urbanized area or urban cluster. In the city context, the entire city is designated an urbanized area, urban cluster if any portion of the city is designated by the census as being urbanized. Counties are a little bit different because counties include both rural and urbanized areas, so it focuses more on the parcel rather than the jurisdiction. It also has to be in an infill location in the sense that at least 75% of the perimeter of the site needs to adjoin parcels that are currently or formerly developed with urban uses. So that basically means any current or former residential, commercial, public, institutional, transit, transportation, passenger facility, or retail uses, or any combination thereof. So if 75% of the perimeter is surrounded by any kind of development, it will be, other than ag, it's going to be eligible if it meets various other requirements. The site has to be designated for residential use. Residential mixed use is qualifying as well, although the residential has to be predominant in the land use designation. So if you think about it from the standpoint that it can't just be mixed use generally, it has to be primarily residential in order to be eligible. Again, as I noted earlier, the project cannot require a subdivision. If it does, then it's not eligible for treatment under SB35. Here's sort of the most important thing for cities and county staff to understand if you've got an SB35 eligible project, how it works. Does the project meet these various objective standards? Does it meet objective density standards? Those density standards are deemed met if the density is within the maximum density allowed by the general plan. You can only apply objective zoning standards. So if you have existing objective zoning standards, the project has to comply with it. Any zoning standards that are not objective, that are subjective, deemed subjective, you cannot apply those. And then you can also apply objective design review standards. The project has to comply with the objective design review standards. The statute goes on to define what constitutes objective design review standards. There can't be any personal or subjective judgment. It has to be uniformly verifiable by reference to an external or uniform benchmark or criterion available and knowable prior to submittal. So the typical design review or architectural standards that you will see, not standards, but architectural review that you will see in a typical design review context, it may be difficult to apply absent some direct written documentation establishing that as a standard. And then finally, you can't apply any growth control measure if you're dealing with an SB35 project. There's a list of sites and areas that are not subject to SB35 treatment. Many of them are pretty typical: wetlands, coastal zone, rent-restricted housing, housing that was occupied by tenants within the last 10 years. There are a number of provisions here that you can take a look at and see. When you're determining eligibility, you definitely have to look at this list. But probably the biggest reason why this bill won't be relied upon a lot is the requirement to pay prevailing wage. Any project that's greater than 10 units is required to pay prevailing wage. And based on my discussions with developers in the development community, their perception is that projects are not going to be economic if they have to pay prevailing wage, and so they don't anticipate pursuing projects under SB35. Now, you will note the sweet spot here that projects under 10 units are not subject to the prevailing wage requirement, which may well make it likely that the sweet spot for SB35 projects will be projects that are less than rental projects that are less than 10 units. So there's a prevailing wage requirement, but there's also the skilled and trained workforce requirement. Some of you may be familiar with project labor agreements, which exist and are a way for the labor community to impose some of the requirements that you see in collective bargaining agreements on projects pursued in the private sector or in the public sector. And the skilled and trained workforce requirement imposes some of those similar requirements on SB35 projects. This requirement doesn't apply everywhere in the state. It only applies in the Bay and coastal counties with a population of 225,000 or greater, and it also applies in other jurisdictions of less than 550,000 in non-Bay and coastal counties. Initially, it only applies to projects of 75 or more, and then it staggers down as time passes. But again, that's likely a costly requirement for developers pursuing SB35 projects. And based on my discussions with the development community, that and the prevailing wage requirement are really scaring them away from pursuing SB35 projects. So Meyers Nave has put together an SB35 eligibility checklist that will help anyone that's either pursuing an SB35 project as a developer or is pursuing or is considering SB35 submittals. The checklist you see here is not very easy to read, but we will be emailing the checklist to all of the attendees. Later today, it has careful cross-references to each of the sections in SB35, so you should be able to carefully go through a project and determine whether or not it's eligible or not as a first pass by reviewing this SB35 checklist. One thing I want to go back to real quick is the determination that HCD will make about eligibility. The way I read the statute anyway, HCD cannot make this determination until April because it's based on a submittal from the jurisdictions that isn't due for the first time until April 1st, I think, of 2018. So given that the submittal isn't made by the jurisdiction until April, there's no way for HCD, in my opinion, to make the determination until then, and therefore SB35 projects aren't eligible for SB35 until at least April of 2018. And with that, I'm going to turn it over to John.
Before we turn to my section, John, I'd like to ask you a question I've had about Sequa and SB35. You know, you mentioned that SB35 says that the decision of the city or county is on a development project is a ministerial one, and on that basis, it appears that no Sequa compliance would be necessary. To me, this strikes me as a very controversial part of SB35, and I'm guessing that opponents of projects will perhaps take a different stand on the Sequa. I just wonder if you comment on, are you expecting that cities and counties really will do the SB35 approvals without doing any Sequa? Are you expecting that there might be litigation from the opponents of projects over the Sequa question? Just curious how you see this working in real life.
Well, I would imagine there will be some litigation over over Sequa requirements and whether mitigation measures apply or not. I guess the way I look at it is the legislature has decided to eliminate discretion in the agency's action on the project, and therefore Sequa doesn't apply. It really is ministerial in that sense. That's what you're getting at, right? The fact that you take a project which is effectively a land use project that would ordinarily be discretionary and require some level of Sequa review, but the legislature, by taking out all that discretion, if you can meet all these requirements, it's no longer a project. There's no discretion involved. It's straight ministerial.
All right, let me pass on a couple of questions from our audience here. One is whether there's a clear definition for a skilled and trained workforce.
There is a clear definition of skilled and trained workforce. I'm trying to find it now. It's a cross-reference to something in either in the government code or the public contract code, and we can certainly put out on the email a response to that.
As I recall, it refers to apprenticeship standards primarily, doesn't it? I think it's a new law.
There are various requirements contained in the skilled and trained workforce requirement, but that's one of them, apprenticeship. And but we can get an answer out to that question.
Okay. We have another question about how primarily residential would be calculated for purposes of SB35.
Sure. Give me 1 second. At least 2/3 of the square footage of the property needs to be residential.
Another question, would a project with a new single-family home and an ADU, or a secondary unit, would it be eligible project for purposes of SB 35? Would it be considered 2 units?
I think it could be. Yeah, I don't see why not. If the project's being pursued as 2 units on a single site, I think it would be considered a multifamily project. I guess I'm thinking that the questioner is thinking of it could be 2 units within one building, or 2 units in different buildings on the same lot.
Like a backyard.
Yeah. In either case, I think a developer could make the case that SB 35 would apply. I'm not sure they would go through all the trouble, given that most ADU ordinances are going to allow that. I'd have to look at that more carefully to think about whether a developer would potentially try to rely on SB 35 in that context.
Okay, let me ask one more question, then we'll turn to the next subject. That is, can a jurisdiction be considered eligible already if it has not submitted its latest production report on time or late? What's meant as the latest production report?
The latest production report, the production report requirement is brand new as of January 1, 2018. So that phrase, production report, that cross-references, I think it's 65400 of the government code, refers to a brand new production requirement, a brand new aspect of the report that agencies are required to submit every year as part of their housing element compliance reporting. So that production report is a brand new requirement. We could all look at our jurisdictions, and in many cases we'll be able to say whether or not HCD is going to deem us eligible, but they can't deem you eligible until that production report is first submitted. So how it works.
Okay. So this is John Getz. Let's turn to the next part of our presentation. And here we're going to be looking at 2 other new pieces of legislation that were part of the governor's package of housing bills, AB 73 and SB 540. And when commentators are looking at this package of bills and looking at the ones that dealt with streamlining of local approvals, they often refer to SB 35 as the stick approach and AB 73 and SB 540 as the carrot approaches to streamlining housing development approvals. These bills are different from SB 35 in that they're voluntary on the part of cities and counties. They carry the possibility of state funding for the planning work that is necessary to set up the districts we're going to talk about. The idea was for the state to incentivize cities and counties to do the upfront zoning and Sequa review that were necessary to create a possibility for streamlined approval process. So they both take the approach of the cities and counties doing that upfront Sequa approval for housing in a designated area. And again, notice that's different from SB 35, where the Sequa process is presumably eliminated entirely. Here, the Sequa approvals are actually done, but just in an upfront time period, which allows the streamlined approval process when actual development proposals come to the city or county. So the first bill we're going to talk about is Assembly Bill 73. And by the way, these 2 bills have a lot of similarities. Not sure why the legislature actually adopted both of these bills, other than it seems that in 2017, almost every legislator wanted to have a housing bill in the year of housing. But these are not a lot different. But we'll talk first about AB 73, and here the city or county can establish housing sustainability district by ordinance, and the areas that get put in the district have to be suitable for this kind of streamlining, and the legislation says this generally means areas that are within a half a mile of public transit or just otherwise suitable because they've got existing infrastructure or transportation facilities or just other things that make it ripe for this streamlined process. The legislation allows the city or county to put not more than 15% of its jurisdiction within the sustainability district. It can have more than one of these districts. Total of these districts can't exceed 30% of the boundaries of the jurisdiction. The district is in place for a 10-year term. It's renewable for another 10 years at the option of the city or county that forms it. The land within the jurisdiction needs to have certain zoning and density in order to be eligible. It's got to be zoned residential by right, and it's got to have density that's appropriate for this, which they define as the density that's used for lower income or multifamily projects, and at least 10 units per acre or areas that are designated for single-family development. So the city or the county in establishing the Housing Sustainability District prepares an environmental impact report for the district, and so when individual projects come to the city or county within this district, the legislation says that the projects basically have to comply with the mitigation measures that are set forth in that EIR that was approved for the district, but they don't have to go through a new Sequa process. And obviously that's a big advantage for a project coming in, knowing exactly what it needs to do to have Sequa compliance. So the incentive for the city or county in this is that it would be eligible for zoning incentive payments from the state, from the Housing Community Development Department. And the idea is that the city or county would submit the district for approval from the State Housing Community Development Department, and upon approval, the state would provide 1/2 of the funds upon approval of the district, and the other half when building permits are actually approved for housing within the district. Now, the legislation does say that the incentive payment is conditioned on appropriation of funds by the legislature, and that's something you should always watch out for. Check on this before starting process, because legislature is well known for setting up programs that require funding and then not actually funding the program in subsequent budgets. So if you're a city or county that's thinking about doing this, definitely check on the availability of funds before you start. Now, when individual housing projects come to the city or county and are within one of these districts, the city or county needs to provide a written decision to the applicant within 120 days of the application, or else it's deemed approved. The city or county can apply uniform development standards and design review standards. So this is more city and county friendly than SB35, which very narrowly constrains the types of requirements that the local government can impose on the development. Still needs to be essentially uniformly applicable standards, but there is some room for discretion where there's not in the SB35 process. Now, these districts do have the requirement, like SB35, of prevailing wages and the skilled and trained workforce requirements, which again is going to chill some of the developer enthusiasm for this approach. There is an affordable housing requirement as well. At least 20% is required, with at least 10% for low income. You'll see this is actually a lesser requirement than the other district we'll talk about in a minute. And for the developer, another important advantage is housing that's developed within the district is not subject to local growth control measures or moratoriums on development. Now, let's turn to the second of these bills, Senate Bill 540, and this is the bill that was sponsored by the League of California Cities. I think it was intended as a local government-friendly alternative to SB35, and perhaps was intended to persuade the legislature not to pass SB35, but we ended up getting both. And this, again, is very similar to AB 73. Here, the city or county establishes this workforce housing opportunity zone by adopting a specific plan and an environmental impact report. There are somewhat different standards for the land that can be within the zone. Can be from 100 to 1,500 housing units permitted within the zone. The specific plan will look at many of the typical aspects that specific plans look at: services and utilities, traffic and environmental, water, and the specific plan is allowed to have development policies and standards, design review standards. Again, it does not give up the local government ability to actually control the development like SB35 does. Densities here somewhat similar to actually I think they're very similar to AB 73, with at least 10 per acre for the single family and the lower income standards for multifamily. And again, when an individual project comes in, no further Sequa review. They've got to comply with the mitigation measures that are in the specific plan and the EIR. There's a different type of financial incentive that is included within SB 540. Grants or loans from the Department of Housing and Community Development. Specifically states that the idea is that the local jurisdiction would get this money perhaps as a loan. It would charge development fees to developers, and that would be the source of repayment for the loans to HCD. So the idea is ultimately the developer will be bearing the cost of the upfront planning. Again, like the AB 73, there's a limited ability to disapprove specific housing projects that meet the specific plan standards, although the development standards and design review standards can be applied by the locality. This also has a prevailing wage requirement, also has an affordable housing requirement. The affordable housing requirement is a bit more than the other AB 73 affordable housing requirements. And here it's 50% as opposed to the 20% in the AB 73. But you'll also see that the affordable housing requirements here are oriented more toward the middle and to the moderate and middle income. And the middle income, I believe, is defined as 150% of median income. So it's really more of what we're often calling workforce housing these days, as well as some very low income, 50% AMI, and low income, 15% AMI requirements. Again, one of the big differences between the districts. So So if you look at the two of them, they both require an upfront planning and Sequa effort. They both include the source of funding, although it's uncertain in either case whether they're available. One thing cities and counties might want to think about if they are interested in forming these districts and zones is that this may be a very good use of funding from the SB2 funds, the permanent source, the legislation that was also passed in this package, and that's the bill that collects funds, $75 on recorded real estate documents. If you listen to our webinar a couple weeks ago, we talked about that and how the funds that are generated in 2018 can only be used for planning purposes, planning to streamline and support housing. These districts, with the upfront Sequa work and the upfront planning work, again, look like they might be perfect. We don't have real criteria yet for how these funds will be dispersed from the state, but this seems like a good fit. And again, both have the onerous prevailing wage and affordable housing requirements. They could shield developer interest and participation. So to the extent cities and counties are thinking about these things, they really need to be careful about undertaking these kinds of efforts before getting a real life sense of whether developers are actually going to take advantage of this or not. There's a real possibility that a lot of money is spent, a lot of time and energy is invested in these districts with little participation because of the prevailing wage and other requirements that maybe make it difficult to do. Now, for jurisdictions that are thinking about some kind of upfront streamlining, it may be useful to also think about other tools that are available in current planning and Sequa law that might work as alternatives to these new districts that were created by the legislation, particularly because some of the existing tools do not have some of the baggage of the two new district laws, particularly the prevailing wage and even the affordable housing requirements. So these tools include the specific plan, and again, remember that is the same tool that's used in AB 73 to set up the district. Housing overlay district, creative zoning techniques that cities and counties often use that may be a good vehicle for implementing some of the same kind of housing housing planning that is the object of the two new pieces of legislation. Within the Sequa area, a program EIR or some other kind of environmental impact report that studies more than just a single project may be a useful tool to for a city or county to establish a Sequa-friendly area of town that allows for the same kind of upfront and comprehensive consideration of environmental effects that the two pieces of legislation are going after, and would allow individual projects to come to the city or county and with this Sequa documentation in place. The program EIR may require further Sequa documentation and analysis, so it may not be quite as useful, clear away the Sequa requirements quite as much as some of the other pieces of legislation, but again, would be worth looking at. Also worth looking at are some of the Sequa exemptions that are on the books that are often underutilized, and I know a lot of cities and counties are somewhat reluctant to really embrace some of these exemptions, but many of these exemptions are really on the books for the purpose of streamlining, the same kind of purposes that we're looking at today. And there are some cities and counties that have really adopted new procedures in order to better use the urban infill exemptions, the affordable housing exemptions that are on the books. There are a lot of requirements there, and sometimes it requires some additional technical studies to be able to establish eligibility for these exemptions. But I would say that the recent case law has been supportive of cities and counties that use these exemptions, and has granted new, has supported the discretion that's exercised by cities and counties, particularly in making the finding that there's no unusual circumstances that prevent use of those exemptions. So I wanted to list these tools just because when a city or county is looking at what it wants to do, if it really does want to create a streamlined approval process, it really ought to look at the whole range of options available, the new legislation and the existing law, and determine really what's best for that jurisdiction and the type of housing that it wants to have and expects the market will bring to the jurisdiction. So that's the end of my presentation.
Okay. John, we had another SB35 question, which I can try to answer. It's how long must the affordable units remain affordable, and can they be converted to market rate units at some point? SB35 says that rental units have to be dedicated as affordable for 55 years, and ownership units for 45 years. The affordability standard is below, I think it's below 80% of the area median. So it doesn't establish very low or low standards. It just says below 80% of median in terms of dedication for affordability.
And I believe the standards are the same or roughly the same in the AB 73 and SB 540 affordability requirements too. We'll take a look though and see if there are any exceptions to that might allow the conversion to market, much as we see in programs like the density bonus, in which an equity share program can be used for the ownership units in lieu of a long-term affordability. I'm not sure if that's available for these programs, though.
I didn't see anything like that. One of the things we should mention about affordability is the legislation is real clear that you're not required to dedicate these units in addition to what's in the inclusionary zoning requirement of the local jurisdiction. So if you have a 10% requirement as an inclusionary zoning requirement, and you dedicate units under the statute, under SB 35, if the 10% requirement under the inclusionary zoning would meet the SB 35 requirement, then you're done. You don't need to do anything more. But if the local jurisdiction has a 15% requirement, then you have to meet the 15% requirement. Any other questions out there?
Well, thank you all for attending today. Oh, we got one more. Would you like to take it, gentlemen?
Okay, the question is, does SB 35 require charter cities to prepare the annual report referenced in SB 35? Prior to this bill, I believe charter cities were exempt.
I do not know the answer to that question offhand. We can try to answer that one offline. I wasn't aware that charter cities were exempted from the reporting requirement.
And I think, isn't this there's a new reporting requirement that just became effective?
Well, John, there's an existing reporting requirement for compliance with the housing element that jurisdictions are required to submit, and that's under 65-400. There's a new component of that reporting requirement that relates to the production goals. And by the way, there's some new legislation out there already, not surprising, based on this production requirement, and it would withhold funding for jurisdictions that don't meet the production requirements that HCD determines under SB35. So, while you might think, well, SB35 isn't going to be used that often, folks we may find that new legislation builds upon some of this preemption that SB35 started.
Okay. Another question, I think our last question here. Do you see any reason why multiple of these new legislative tools can't be used simultaneously, such as Housing Sustainability District and the Workforce Housing Opportunity Zone, for projects that meet the strictest of the qualification criteria? So I think the question would be, would you form a district form districts for the same area, fall within both the SB 540 district as well as the AB 73 district? There's nothing in the legislation that prevents that, and perhaps there would be some way of tailoring the EIR to cover both of those, so there would be an efficient way to do that. I don't know if there's a huge advantage to one over the other, but again, I would say take a look at your situation in your jurisdiction, see if you are in that situation where one district might be more favorable than the other, and perhaps I find it unlikely that you would get two pots of money from the state to do both of these on the same area, but there may be some reasons why you'd want to have some overlapping there to capture particular nuances of each. Can't think of a particular advantage, though, to one over the other.
The next question relates to SB 35. Would jurisdictions be required to monitor or ensure prevailing wage compliance, and if so, how would a jurisdiction go about ensuring compliance? My recollection of the statute, and I haven't looked at this aspect in detail this morning, is that the applicant is required to certify that they're going to comply with the prevailing wage requirement, and so the jurisdiction doesn't actually have a monitoring obligation. Now, any project that's subject to prevailing wage in the jurisdiction, it comes with certain prevailing wage monitoring and reporting obligations for the jurisdiction. So there is some of that, and your public works staff's already doing that on some of the projects in town that are subject to prevailing wage, like street projects and things like that. So that level of monitoring, I think, is all that's required. And it's not burdensome or onerous, as far as I know.
Awesome. Well, thank you all for attending today. We appreciate your questions and being with us on your lunch break. Early next week, we'll circulate a copy of the PowerPoint along with the SB35 checklist. Thanks so much. Have a great day.